As you may have seen in the previous videos in this series, there are very limited grounds upon which an adjudicator's decision may be challenged in the courts. Typically, the court will automatically enforce an adjudicator's decision in accordance with the well-known maxim that the losing party must pay now and argue later. However, if the party seeking to resist enforcement can show that there was a breach of natural justice or that the adjudicator exceeded their jurisdiction, then the court may decide not to enforce the adjudicator's decision. This video focuses upon the natural justice branch of these challenges. In the case of Carillion Construction versus Devonport Royal Dockyard, the courts accepted that there had been a serious breach of natural justice by the adjudicator and that their decision need not be enforced. Natural justice is the right to a fair hearing. The main factors which could suggest that there has not been a fair hearing are apparent bias on the part of the adjudicator or a failure to allow the parties an opportunity to put forward their case. It has been repeatedly confirmed that the breach of natural justice must be significant and/or causative of potential prejudice to persuade the courts to decline enforcement of an adjudicator's decision. There are no reported cases where an adjudicator has shown actual bias to a particular party, but the appearance of bias by the adjudicator is sufficient. The test that is used is, might a fair-minded and informed observer conclude that there was a real possibility of bias? Cases where apparent bias has been established, leading to the court declining to enforce an adjudicator's decision, include where the adjudicator has spoken to one party without informing the other party of the conversation, where the adjudicator had previous personal dealings with one party, where the adjudicator has an ongoing professional connection with one party, for example, owning a significant number of shares in one party, where one party has made false assertions to prevent the appointment of a particular adjudicator in favour of another, or where the adjudicator has been shown a without prejudice offer made by one party before the adjudicator makes their decision. It can be difficult to show apparent bias on the part of the adjudicator. Moving on to other areas breaching natural justice, there are a broad range of actions that can be grouped as a failure to allow the parties to put forward their case. These include failing to consider a particular document or submission from one party, or restricting the scope of the adjudication and therefore failing to have regard to a party's legitimate defence. A failure to give parties an opportunity to comment on the adjudicator's approach to a particular dispute. For example, where the adjudicator relied upon an expert report which the adjudicator had independently commissioned and had not circulated to the parties, or where the adjudicator relied upon one party's company accounts when neither party had referred to these in their submissions, where the adjudicator used their own knowledge or experience which could not be derived from the submissions of the parties. Finally, where the adjudicator takes advice from others, for example, a barrister acquaintance who was not involved in the case. As before, these grounds can be difficult to establish and are dependent on the facts of the particular case. In summary, there are two limbs to the argument that there was a breach of natural justice during the adjudication procedure. First, that the adjudicator showed apparent bias, or secondly, that there was a failure to allow the parties to put their case. If you are able to successfully show that either of these limbs applied and that it was significant and or causative of potential prejudice, then the adjudicator's decision may be set aside. It is important to remember that such cases are rare, and in the great majority of adjudications, the losing party will be required to pay the sums awarded to the winning party.